balance that
Well, that's
concern.
another issue. I never would allow very seldom would I ever allow somebody out on.
I would never. Very seldom would I ever allow somebody out on bond who I felt was incompetent. It's just too difficult, actually, to do a competency when they're out. That is a retired judge with 36 years on the bench, reacting to a decision out of Vinton County, Ohio, that he clearly cannot square with the law. To understand his alarm, picture the signature itself, a shaky, almost illegible scrawl at the bottom of a $300,000 bond document, signed by a 73-year-old man his own attorney says cannot grasp the proceedings against him. The ink dried, the door opened, and the system looked away. The paperwork already knew.
Gary Cider Senior is 73 years old. He's a grandfather to more than 16 children, and he's accused of serious felonies related to 16 of those grandchildren who were pulled from his home in Vinton County, Ohio back on June 30th. Gary Cider Senior has pleaded not guilty to the charges. So has his wife, Christina Ciders, and his son, Gary Ciders Jr.
Gary Cider Senior is the grandfather of 16 children removed from a single home in Vinton County on June 30th. He faces serious felony charges. He pleaded not guilty. So did his wife, his son, and his daughter-in-law, the mother of those 16 children. The county prosecutor has said repeatedly that the family was hiding the children.
And the prosecutor said they were hiding these kids. So that suggests that you did know what you were doing was wrong if you're quote-unquote hiding the kids. They were once enrolled in school, and then they didn't go to school.
Well, that's a good point. Exactly.
Hiding children implies intent, an understanding that what you are doing is wrong. If you know to hide, you know the difference between lawful and unlawful conduct. That is the definition of consciousness of guilt.
Maybe we'll learn more about that at a later date. On Monday, August 4th, Gary Cider Sr. signed a signature bond, and you can see from his handwriting, the signature isn't the best, but it's there. Maybe that is because of his medical condition, or maybe he just has poor penmanship. We don't know. But Gary Cider Sr., it would appear, has been released from the hospital, and he has to follow a number of conditions, such as
On Monday, August 4th, Gary Cider Sr. signed a signature bond. The handwriting is barely there. A thin, wavering mark on the page. Maybe a medical condition. Maybe poor penmanship. No one has clarified. He was released from the hospital. He must wear a GPS monitor. He must appear in court, and with that, he walked free.
Lawyer Dorian Baum was here on Crime Fix last month and discussed his concerns about his client's mental state and mental capacity.
He obviously understood a person greeting him, but again, as I noted in my motion, he definitely had some confusion about the process, about what was going on. He had an inability to discuss with any sort of sophistication the legal process, what everyone's roles were, which again, as I've said in here and elsewhere, competency is a bedrock. It's a bedrock precondition to be able to move forward in any criminal case. And if you don't have that, you just simply can't.
His own attorney, Dorian Baum, had already described a man adrift. Confusion about the process, an inability to discuss the legal system with any sophistication, a person who could greet you but not assist in his own defense. Competency, Baum reminded the court, is a bedrock precondition. Without it, you simply cannot move forward.
Is he a danger to the community? I would have suggested he's never been a danger to the community, and certainly in his present condition, he isn't. He is not dangerous. What I would consider him to be is a sad and sympathetic character, primarily because of his general level of confusion and both the mental health and physical issues that I was sort of seeing. And when you ask what I was sort of observing, it was very similar to what we've all seen during the preliminary hearing and his behaviors and mannerisms there, where there was just a general lack of confusion, inability to hear very well, certainly mobility issues, and an inability to sort of in any way discuss with sophistication what was going on.
Baum described him not as dangerous, but as a sad and sympathetic character, physically diminished, hard of hearing, mobility impaired, and generally confused. The man seen in the preliminary hearing appeared lost. But confusion is not grounds for release. It is grounds for evaluation.
A little bit about Gary Cider Sr. being released on this bond, signature bond. We knew this was going to happen. He was being treated in the hospital for a serious medical issue. So he's signed a $300,000 signature bond. Talk to us about, break down what that means.
I've never done one of those. I've never done a signature bond where if he doesn't show up, he owes 300,000. Where are they going to get the 300,000? He doesn't. Does he have?
The mechanism used was a 300,000 signature bond, an unsecured promise to pay if he flees. But as the retired judge noted, where would a 73-year-old man with no visible assets find $300? The bond is a legal fiction. The real calculus was something else entirely.
First, let me stress, the community is not at risk because of this bond. That Mr. Cider Senior has a serious medical condition that requires specialized care in a hospital outside of this area. The county was going to be on the hook for his medical care. And again, based on the information that we were provided, his medical care could potentially bankrupt Vinton County.
The county prosecutor stressed the community was not at risk. Then came the real reason: Gary Cider Senior has a serious medical condition requiring specialized care outside the area. The county would be on the hook for that care. And based on the information provided, his medical costs could potentially bankrupt Vinton County.
Potentially his medical expenses. I mean, this is a poor county with an $8 million a year operating budget. So they don't feel he's a threat to the public.
That's true. Well, of course, that's true. Yeah, that's a point. That's a good point too. That's a good point in the judge's consideration. That's true because it's a.
Vinton County operates on an $8 million annual budget. That is the entire operating fund for one of the poorest counties in Ohio. A single catastrophic hospitalization could consume an unsustainable share of public resources. So the state faced a choice: detain a man it claimed was not dangerous, or release him and avoid fiscal collapse. It chose the budget.
That's been raised. So how do you square that, having somebody out on bail, when you're saying you don't think that they are potentially competent to stand trial? So how do you balance?
But here is the contradiction the retired judge seized on immediately. The same man released on bond is also the man whose competency has been formally challenged. So how do you release someone you simultaneously argue may not understand the charges against him? How do you square that circle?
A lot of defendants fake it. They try to fake it. A good examiner will have them watched and will review video of them when they're not there and pretty much clear up the faking. Because a lot of times when they do the interview, they'll fake, but they record them in jail and how they interact with other people. And then suddenly the psychologist or psychiatrist shows up and they act goofy, Well, they are obviously faking. But the only way you can do that is I would have at least kept him in for the competency evaluation because.
And then the judge raised a darker possibility, one that hangs over every competency claim in a high-stakes case. Defendants fake it. They try to fake it. A good examiner reviews jail video, watches how they interact when no psychologist is present, and clears up the performance. But you can only do that if the defendant is in custody. Release them and that surveillance evaporates. The paperwork already knew.
Vinton County.
Lawyers for all four Ciders family members are raising the issue about whether their clients are competent to stand trial. Yes, now all four of them. Just today, Elizabeth Cider's attorney filed a motion asking for a competency exam and an evaluation to see.
Now consider the timing. Lawyers for all four Cider family members have raised competency issues. All four. Elizabeth Cider's attorney filed just today, requesting a competency exam and an evaluation for a potential not guilty by reason of insanity plea.
Of this motion, the defendant has not been indicted, and therefore, counsel does not have all of the facts, evidence, or circumstances of this case or the defendant's subsequent arrest. However, in the interim, counsel has met with the defendant on numerous occasions and for extended periods. During these interactions, counsel has been able to observe the defendant's demeanor, conduct, and comprehension. These interactions lead counsel to believe that the defendant may be suffering from significant mental health issues. And
the motion, signed by attorney Tommy Staley, reads, counsel has met with the defendant on numerous occasions and for extended periods. These interactions lead counsel to believe that the defendant may be suffering from significant mental health issues, and that competency may be an issue and a clear impediment to the defendant's ability to assist in her own defense.
Four defendants. Yeah, we have four defendants in one family saying, their lawyers are saying, we have concerns about their competency, about their ability to help in their defense and understand these proceedings. Do you feel like she's the youngest of all of them?
Well, in cases like this where it seems like it's pretty open and shut, it's a pretty serious case. They're all caught right there with these kids and not taking care of them. there's not much of a defense. So hey, let's try NGR, let's try competency, and then let's hopefully they'll be found incompetent and they can't be prosecuted, or maybe they'll be, if they determine they're competent, then the next issue is they do not guilty by reason of insanity. It's a common tactic. I mean, the defense, they're just doing their job, you know. They don't have a lot to go on. So if, yeah, we'll go incompetent. Or
4 defendants, 1 family, all suddenly unable to understand the proceedings. The retired judge saw the pattern immediately. When the facts are overwhelming, and here the children were found in the home, in conditions authorities describe as squalor, the defense pivots. First competency, then not guilty by reason of insanity. It is a common tactic. The defense is doing its job, but that does not make it true.
And the prosecutor said they were hiding these kids. So that suggests that you did know.
And the prosecution's own words undercut the insanity argument. They say the family was hiding the children. Hiding requires planning. Hiding requires knowledge that what you are doing is wrong.
Right.
But that was the excuse. Because you wonder what, they weren't in school. Why weren't they being monitored? Why, you know, where's the truant officer, you know? But they evidently said they were homeschooling them, but then they didn't monitor that either. It's just a mess. This county is something else, I'll tell you.
The children were once enrolled in school, then they vanished from the system. The school record said, homeschool, but no one monitored. No truant officer followed up. The infrastructure designed to catch exactly this kind of disappearance simply did not work. For this to happen, the judge said a lot of things fell through the cracks.
Yeah, and I think that's a good point because Elizabeth Cider's brother has posted on Facebook that he thinks the other ones are faking it. He thinks that
they're all faking, yeah.
And then there is the voice from inside the family itself. Elizabeth Cider's own brother posted publicly that he believes the others are faking, acting goofy, as he put it. A family member calling the competency claims a performance.
And jail calls.
And jail
calls.
These people are these criminals don't realize how they're constantly being monitored by the police and the prosecutor's office. We have full confessions on jail calls sometimes. They try to make up alibis. It's just amazing what comes through with jail calls. It's just, it's unbelievable. And then through the jail calls, they can tell, well, gosh, this person's obviously competent. And a lot of times,
And the judge knows how this ends. Jail calls, recorded interactions, the constant surveillance of custody. These are the tools that separate genuine incapacity from theater. Defendants confess on recorded lines. They make up alibis. They say outright, I'm faking, I'm acting goofy. It happens constantly. But Gary Cider Senior is no longer in custody. Those cameras are gone. The evaluation just became exponentially harder.
Now, 3 of the Cider's family members remain in the Southeast Ohio Regional Jail on a $300,000 bond. Only Gary Cider Senior is out on that signature bond. And remember, we have a great app where you can review all of the
3 of the 4 Cider family members remain in the Southeast Ohio Regional Jail on $300,000 bond. Only Gary Cider Senior is out, released on a signature he may not have understood, for a crime he may never be tried for, because his medical bills were too expensive for the county to bear. The paperwork already knew.
The documents and our episodes about this case. It is Law and Crime Plus. Check it out. Go to the case file section. You won't regret it.
The bond document is public record. It is available through the Vinton County Clerk of Courts. Read the signature. Read the motion filed by his attorney questioning his competency. Then ask yourself, if a man is too confused to stand trial, what exactly did that signature mean?